Welcome to part one of our three-part series on the legal instruments that you will analyze as practitioners or as students of international and European law. Let me take a moment to explain why this series exists. First of all, in international law, there are sources that are different from the types of sources that you would encounter if you were practicing law in a national jurisdiction. And for that reason, in this course, we want to look at the instruments that are commonly seen in international law. Those instruments will be talked about in our three-part series. Here in part one, we will focus on treaties and statutes. This lecture will contain the following elements. We first looked at the instruments of international and European law. We will look at an analysis of treaties and statutes, and then we will look at how to interpret the information found in those treaties and in those statutes. All students of international law know that in Article 38 of the Statute of the International Court of Justice, we have a list of the sources of international law. That list helps us to understand as students and practitioners what types of legal instruments we're likely to encounter in the practice of international and European law. This is another way to look at that same Article 38. Think about law being broken down in principal and subsidiary types of sources. And then looking at those subsidiary and those principal sources, we can ascertain that treaties, customary rules, general principles of law, judicial decisions, and the writings of highly qualified scholars all make up sources in international law. It's then our goal to look at some of these sources and to learn how to analyze them so that we have a framework for writing about international and European law. I would like to suggest that when you're looking at a treaty or a statute, that you take a moment to think about the purpose of the statute, the structure of the statute, and the content of the statute. Those three categories help you to better understand why the statute or the treaty exists. To understand how the treaty is set up, and also to know and understand the content that's inside of the treaty or the statute. This can work, as I note on this slide, for both instruments. But in the case of treaties, which are so much a part of international law, it's always important to understand that the purpose is often related to the historical moments prior to the treaty and its founding. And so often there will be a preamble that discusses the prior international law and why this particular treaty is necessary. The structure of treaties is often very similar because after your preamble, you often have the operative sections, the sections that are binding on the parties to the treaty. But then there's usually some sort of an administrative section, a section that talks more about who's supposed to monitor the treaty or how to enter into the treaty, how to become part of the treaty. Those types of things will be discussed in a later section. And finally, in both the sections of treaties and also in statutes, there can be sort of post-treaty or post-statute, a part that might be a protocol, or in the case of a statute, an amendment. And this information, of course, is also very important and must be analyzed when you're looking at the overall treaty. Finally, the content of the treaty, of course, is very important. What rights are listed there? Who has the obligations in the treaty? Whose behavior is being regulated by the statute? And what are the consequences if you don't comply? These are all things that you would consider as you read through the content of a treaty or statute. Let's find a treaty on the internet and let's see how it's set up. So I'm here at the Office of the High Commissioner for Human Rights of the United Nations, and they have on their website are most of the human rights treaties. So here I am, and we're looking at the International Convention on the Elimination of All Forms of Racial Discrimination on the website. And what I notice is that it starts off with just some basic statements or declarations that that relate to the state's parties. And it doesn't seem to have anything operative in it, but it is referring to historically important documents and events. And then after that, I come to part 1. And part 1 seems to have definitions, for example, in Article 1. But then it seems to also explain what the state's parties to the convention are undertaking when they agree to this. So this looks like the operative part of this particular treaty. I'm just continuing to scroll through, and I come to then part 3 of the convention. And in part 3, it seems like it's the administrative part of the convention. So it seems to be discussing how to become a party, how to sign on, how to accede to the treaty, etc. And this, again, is important in that it gives us information about the administrative portions of the treaty and how it's carried out. And that's the end of our treaty. So if I were going to somehow represent this, I might put together a quick outline of the treaty showing that there's a preamble referring to some important parts of the historic times coming up to the signing of the treaty. And then part 1 seems to have the state's parties' obligations. I looked at part 2 and 5 in particular. They talked about obligations to take measures to review governmental, national, and local policies. Article 5 talking about the rights that should be enjoyed without racial discrimination. Then in part 2, I noticed that there's a establishing of a monitoring committee, the Committee on Elimination of Racial Discrimination, and part 3, administration questions. So how do you access to it, the convention, and it looks like the ICJ has jurisdiction if the parties have a dispute over the measures inside of the convention. So again, looking at a treaty online, we were seeing how to find the structure of the treaty to help us be able to better analyze what's happening with the treaty. So then, after looking at a treaty, how would you now know how to interpret the treaty or the statute? And when I talk about interpretation, I'm not referring to the interpretation that's discussed, for example, in the Vienna Convention. Instead, I'm talking about who has the right to tell you what the individual articles or sections of a treaty or statute mean. And often in the case of treaties, there will be a body, a court, or a treaty body that has the authority to interpret the sections of the treaty. And so it's important as practitioners, scholars, and students of international law to know how to access that information, to know how to find the comments to a treaty, or to know how to find the court's cases in which they interpret sections of a treaty. Another way, however, that international law treaties are interpreted is through the eyes of a judicial scholar, someone who has expertise in international law that is distinguished in the field and who writes about provisions of treaties or even about how they're interpreted by their interpreting bodies or their courts. And so scholarly articles also become very important in interpreting statutes. In parts 2 and parts 3, we are going to look at those types of instruments, the instruments of monitoring bodies or courts, and scholarly articles. But to continue our conversation here in part 1, we will look at now the treaty and how you can write about a treaty. So we know that legal analysis is done cognitively. That is to say, we have to use our brains and our minds to look through and understand the provisions of a treaty or a statute. But often that cognitive analysis has to be transferred onto paper. It has to be put in writing. It has to be digitalized in some way. And so when you're writing about a treaty or a statute, you might keep these 5 ideas in mind. You might keep the idea that your writing needs to tell the name of or the title of the treaty at some point. It also needs to discuss the date that it's been enforced, the main purpose of the treaty, maybe even quote some specific provisions, and then talk about how the provisions have been interpreted. So a very good explanation of a treaty will have all 5 of these points in the explanation. Here's a sample written passage. It's completely fictitious, but you can use it as an example of what you might say about a treaty when you get ready to write about it. This is putting your cognitive analysis into a written form. Take a moment, pause this recording, and read through this sample passage.